Sir, well, let me zero in on this. Well, si Justice Leonen yesterday, in very emphatic terms, almost branded the case that was the cases that were filed as premature and not yet ripe, not yet ripe for filing. And he said that parang there was failure to present an actual case that would warrant Supreme Court action. Now, I pointed out kasi, of course, he is only one of 15 Supreme Court justices, but he is also widely perceived by many to be the more sympathetic justice, considering his background in public interest law. So let me ask you po, where does this leave the petition? Does his concern have any merits from your point of view?
Well, Ed, in my experience, the way a justice would interpolate will not be a good assessment of what he's going to decide on.
Okay, his vote. Mm-hmm.
That will be an associate justice might just be playing the devil's advocate.
Mm-hmm.
So you cannot divine exactly what he is going to vote upon. So in this particular case yesterday, the Justice Leonen interpolated Attorney Molo, but we should be more concerned on the state of jurisprudence, because under our jurisprudence, a particular law can be challenged facially. Mm-hmm. That means to say, on the text of the law itself, without an actual case happening, if there is an abridgment of the freedom of the press, of expression, and of speech. And in this particular case, that is almost all of the 37 petitioners made out a case mounting a facial challenge, which does not need any actual case to happen. The petitioner said that the freedom of speech is being restrained by certain new crimes being introduced in the ATA, like, for example, proposal to commit terrorism,
yes,
inciting to terrorism, threat of terrorism, which are all articulated. So that involves the freedom of speech. In this case, because the law is vague and overbroad, then the citizen does not know what act in particular he should avoid. Yeah. So in that particular case, he is chilled into silence. He's cowed into silence. His right to free expression is actually frozen. In that particular case, there is no actual need. There is no need to wait for the happening of an actual case, because the abuse and derogation of civil rights are embedded in the law itself, not in the speculative field of the petitioners that the police or military enforcers will abuse the law. The abuse is in the law itself.